Welcome to Fundamentals for Startups, a CoMotion Labs production. My name is Caroline Hansen, and I am manager at CoMotion Labs Technology Incubator at Startup Hall, and I am your host today. If you've joined us before, you know that CoMotion Labs is a multi-industry incubator hosting early-stage startups from both inside and outside the UW community. We are committed to nurturing and enabling the success of our startups, contributing to critical infrastructure and opportunities for learning, mentoring, and networking. And we do this without taking equity or IP. We have 3 incubators in 2 locations on campus: Life Sciences and Hardware in Fluke Hall and Tech here in Startup Hall. If you are a founder looking for a community to help your startup grow and flourish, we'd love to talk to you. Fundamentals for Startups is a regular lecture series open to anyone interested in learning about entrepreneurship or building a startup. Every week, we bring in experts with diverse perspectives and experiences to share insights, inspire action, and offer space for questions. A few announcements before we get started. All the Fundamentals for Startups presentations are archived on our YouTube channel and on the CoMotion website, where you can filter by topic. To learn about and register for future Fundamentals events, visit CoMotion online and subscribe to our YouTube channel. Today, I'm excited to introduce Amy Royalty and Cody Nunn, attorneys at Ryan Swanson in Cleveland. Amy and Cody are immigration attorneys whose firm has worked with employers of all sizes across industries to secure temporary visas and permanent residency for foreign talent in the U.S. since 1965. Today, they will talk about the variety of immigration options for startups and entrepreneurs and compliance protocols. Welcome, Amy and Cody.
Thank you. Thank you. Welcome, everyone. Thank you for joining us on this beautiful sunny Friday. I actually returned from Hawaii recently, and I was surprised to see the weather was better here than it was in Kona, Hawaii, where there was quite a bit of rain. So I'm not sure that the slides are forwarding or working, but I'm an immigration attorney. My name is Amy Royalty. I've been practicing immigration law for over 20 years with Ryan Swanson for the last 10 years. And I primarily work on business immigration. That's working with companies of all sizes, including temporary visas and permanent residency for individuals in the United States. And it's very exciting to work with small companies, especially startups, and growing and that size of companies, because thankfully there are a lot of visas available, a lot of different visa options, and primarily because so many companies in this country are started and owned by immigrants. So it's clearly very important to our U.S. economy to have visas for immigrants. This is my colleague, Cody.
Hi, I'm Cody Nunn. I'm also an immigration attorney at Ryan Swanson in Cleveland. I've been practicing immigration law for about 9 years, focusing on business immigration or employment-based immigration categories.
So we're really excited to be here and join you and talk about some of the developments and different types of visas, both temporary and permanent, that are available to founders of startups as well as employees of your startup company. So basically, the U.S. immigration system is made up of 2 different types of visas. When we use the word visa, it actually is more of a travel document, but it's a very commonly used word in U.S. immigration. There's non-immigrant visas, and those are temporary visas. That allows someone to come to the U.S. or stay here on a temporary basis. And then there's immigrant visas. That's synonymous with a green card or permanent residency, which allows someone to stay or come to the U.S. and work on a permanent basis. So for startups, there's different visa categories. It's kind of the alphabet soup is what we call non-immigrant visas in the U.S. Primarily, the different visas used are the F1 student visas. So if you have a foreign student who's attending a university, often they are here on an F1 student visa. And then the work options for those students are OPT or STEM EADs or even CPT, which is curricular practical training. There's also H-1Bs. That we're going to spend some time on. That's where you hear about the H-1B lottery every year. That's for someone working in a specialty occupation. There's E2s, that's for someone who invests in a company, a treaty investor or trader. L1, that's for a company that might exist in another country to start up a new company or office in the US. There's the O1, that's often used in science or business for individuals seeking temporary status. It's a way to get around the H-1B lottery, and it's a really good option. It's for someone who's shown extraordinary ability in science or business. Then there's also EADs for dependents of someone on a work visa, like an L1 or an H-1B. And then we're going to cover a little bit about the different types of green cards for startup founders or owners, like the EB-1A petition or national interest waiver. So when you're trying to find an employee or hiring someone to work for your business, the types of visas you'll see or categories that they might be able to work on would be, again, the F1, an OPT or STEM EAD, the treaty investor, that E2 visa, the H-1B. There's also TN, someone who, this is under the USMCA or formerly NAFTA treaty. If someone's from Canada or Mexico, they can get a work visa and work for your company. And then there's the O1, and again, the dependent type work permits of someone who's a dependent of an H-1B or L1 visa holder, or E2 visa holder as well.
Okay, so we're going to jump right in and talk about student F1 visas. As Amy kind of mentioned in our earlier slides, students can work in the United States with a variety of different ways. One is curricular practical training, another is optional practical training. And if a student is studying in a STEM field, they can extend that optional practical training additional 24 months. The original optional practical training is, it will allow a student to work for 12 months. So we're going to focus on OPT and STEM OPT instead of the curricular practical training, as the OPT employment authorization is more friendly to startup entrepreneurs and employees. So to get right into it, a student can work for a period of 12 months after the end of their program for any company, as long as the work is related to their degree field. And so this can be a student who just graduated and wants to join a startup as an employee, or a student who's interested in founding a company, becoming an entrepreneur. They can certainly do that with an OPT, as long as the business is still related to their degree, and they have the proper business license for that entity.
So we just had a question about somebody that had more than one employer for an OPT, switching from first year to extension.
Hold on, we're going to actually, if you could use the microphone, that would be great.
We just recently had a question come up with a person that was working with us. They were in their first year at OPT and they had multiple employers. And the question was the minimum hourly requirement. Did that change when they switched from the first year into the STEM extension? Like, did it have to be like 20 hours per week per employer, or 20 hours per week for all the employers put together, or 20 hours per week for at least one employer?
That's a good question. They have to work for at least 20 hours, as long as it is full-time overall. I think that should be okay, but
I think they could do 20 hours on the STEM EAD, so like let's say 10 hours per employer. Each employer would need to be registered with E-Verify, complete an I-983 training plan, and for the STEM EAD you have to have an I-20 for each employer. That's really important. It's a little different for OPT. It's a lot more flexible in terms of working with different employers. You can have one employer listed on the I-20 and actually work for a different employer without getting a new I-20.
You have to still mention it to your school that year.
Right. So they should update like the SEVIS.
Yeah, for sure. So for STEM, I guess we can extend to the next.
Sorry. We'll go to STEM. STEM
For
EADs.
STEM,
Any other questions
about
OPT?
Yes.
Yes?
So like we have to work more than 20 hours, but there's no upper limit, like for how many hours you have to work, right?
No upper limit. I would say it should be reasonable.
To comply with wage and hour laws, but otherwise, yeah, you can work more than the 40 hours.
So STEM OPT is for students who studied in a STEM field. They can extend their OPT for an additional 24 months. So that means they could work for 3 years after the end of their program. The STEM OPT is a little bit more restrictive than the OPT, just because the employer who the student is going to work for must be enrolled in E-Verify, and the employer and the student must complete a training plan that's related to the degree. And the training plan has to kind of detail what type of work the student is going to be doing, how it's related to the degree, what kind of training goals they are going to meet, and how that student is going to be supervised and evaluated. And so that could be a little bit tricky for a founder, right? How are you going to train yourself? The answer is you're not permitted to complete a training plan for yourself. So if you are a student who's interested in founding a company, you must be able to form the company so that you have a bona fide employer-employee relationship. And so, you're being supervised and mentored, and somebody else could potentially fire you. And
could that be like a board of directors?
Yeah,
like if you're the founder CEO, let's say?
Yeah, I think so. It just has to be in a way where the student is actually getting training and is not supervising themselves, right? And so that's why we put self-employment may be acceptable, it may not, depending on the type of formation that you have. Same with third-party sites. You could work in a third-party work site, but you have to still have a employer-employee relationship with the employer that's supervising you and providing you with the training. Oops, sorry.
Anything else on STEM EADs? Does anyone else have questions? It's a great option. Obviously, everyone has heard about the H-1B lottery and how difficult it can be to get that type of work visa. So having that additional 2 years of work authorization after your post-completion OPT EAD expires is super beneficial. We've had a lot of folks, try for the lottery a few times and only recently be selected. So yes, a question in the back here.
How early do you need to start looking into the STEM OPT process before they graduate? Or is that something that happens, the process starts as they graduate, or do you have to do some work prior to that?
Oh, that's a good question. Generally, you do the OPT first. So I believe you can start the application process 90 days prior to graduation. So you talk to your school about how you apply for your OPT. You need to apply for an actual employment authorization document with USCIS, and you won't be able to start working until you get that card in the mail and in hand. So you want to think about that timeline. If you have something lined up and you want to start working, you got to keep in mind that you have to have that card in hand first. For the STEM extension, it might be a little bit harder to plan, but once you're getting closer to the end of your initial 12-month period, you can apply for that STEM extension. You'll want to talk to your employer, make sure that they are enrolled in E-Verify, and then you want to talk to them about completing the STEM training plan. Once you complete the training plan, then you talk to your school about getting an endorsed I-20 for the STEM extension. Then you would file for another employment authorization document, again with USCIS. For the extension, though, you may work while that EAD is pending, unlike that initial OPT EAD card.
Yes, another question?
Oh, you mentioned this as potentially a possibility for people who want to be a founder. How much more difficult is it to do that versus joining a company?
So the question is how much more difficult is it to get the STEM EAD as a founder as opposed to as an employee of a company? What do you think?
I would say it's probably harder.
Yeah.
You'd have to show how you're being trained.
Yeah.
It might be difficult if you're the founder, and you must be doing work that's related to your degree, right? The training has to be related to what you studied, and you have to be able to show that employee-employer relationship.
Yeah.
You know, whereas if you're an employee, you just have to be trained and have the required STEM degree. So I would say it's much easier to be an employee than.
But every time you change employers, you have to get a new training plan and get a new I-20 to approve that employment within 10 days of starting. So you could do it after you start at the new company, but you got to get that done very quickly. Yep.
Just a quick follow-up. So in terms of the employer, how expensive it is to go through this process, and just how many resources in general would a small startup expect to invest in the STEM extension?
That's a really good question. The good news there is that the filing fees are not as high as some of the other categories that we're going to talk about today. For instance, in H-1B, the Immigration Service just increased those filing fees as of April 1st, and they are very high, even for small employers. But the STEM EAD, the cost of the EAD application is the filing fee involved, and that's like $520 now with the new filing fees. Legal fees, you know, you don't even have to work with a lawyer. You can do the training plan on your own. Sometimes we assist employers just because they have no idea where to start, and just make sure that, again, the I's are dotted and the T's are crossed and everything is meeting the requirements. But the DSO at the school you're at can also assist with that, review it, make sure it meets USCIS requirements.
I agree. Yeah, there's no requirement that the employer has to pay for any of these fees, so the student can certainly cover it. I think that's more common. What
I think
we
with
see.
STEM extensions, especially, a lot of the students pay like the filing fees.
Yep, and some schools also have a program management fee as well. It could differ, but again, usually the student pays for those fees.
Okay, so I think we've covered STEM extension. We want to talk about the big monster in the room, the H-1B.
Yep, probably the most common visa category that you might hear of, the H-1B visa category. And this is an employer-sponsored visa category. And so in order to sponsor someone in H-1B status, you must have a position that's specialized and requires a bachelor's degree or higher to perform, that's in a specific specialty field, right? And then the employee that you want to sponsor must have a bachelor's degree or higher in that same specific specialty field. So for example, if you're an employer and you need a software engineer, right? Usually a software engineer does require a bachelor's degree in computer science or related specialty field. The employee then must have a degree in computer science or related.
An associate's degree does not meet that requirement.
No.
It needs to be a bachelor's.
It needs to be a bachelor's. It could be a foreign degree, but it has to be the equivalent to a U.S. bachelor's degree. In some cases, you could also use your professional experience. If you have a significant number of years of experience, you can equate that to a U.S. bachelor's degree. And so we just put some common specialty fields down there: engineering, computer science, accounting, law. Although business is it's hit or miss, maybe depending on the administration that we have.
Currently, it's pretty favorable for H-1Bs, so they're approving the H-1B.
Right.
Like folks with business or marketing, certainly finance, quantitative type, degrees, statistics. The other one that's new is data science, right? So there's more fields, there's more occupations, thankfully, under the Department of Labor's occupational category. They have data scientists is one of the occupations now.
They just updated it.
And they have BI analysts, which we never usused to be able to get approved for an H-1B, but currently, those can get approved. So that's good news. At least right now.
Yep, at least right now. The tricky part about business is that sometimes, it's hard to say for this business role, it requires a degree in business in a specific business-related field, right? Or for example, maybe somebody who's doing advertising or marketing, right? It's nice to have a degree. It's probably very specialized, but
We have a question.
oh, sorry.
That's okay. I also have a question from online. Does a master in healthcare administration fall under a STEM degree?
Oh, good question. There are a lot of new STEM fields. I think it does. I
think
always
so.
want to double check on the STEM degree list, and I would recommend that you check that list, which is regularly updated. So make sure that you're checking the most updated list. I think it probably would.
I would
Most healthcare professions
Yeah.
do qualify as a
I
STEM
would think
degree.
so too. But there is a list, even online, you can check. It has all the majors that qualify for.
There's a
STEM.
lot of creative, like information management. I mean, there's just all kinds of degrees and ones I've seen from UW, you know, that qualify.
Yeah, for
These
sure.
days, like all those interactive design, human-centered design, human-computer interaction, that all is, you know, on the list. So that's helpful.
Right. And then the H-1B status, you can get an initial period of 3 years, but it's a maximum period of 6 years total. And so your employer would extend your H-1B status once to get the maximum 6-year period.
So you've all heard about the H-1B lottery. That's sort of how H-1Bs are allocated on an annual basis. And unfortunately, those numbers have not increased despite the incredibly high demand for H-1B visas. So right now, there are a total of 65,000 H-1Bs available for individuals who have a foreign bachelor's or higher degree or a U.S. bachelor's degree. And for individuals who have a U.S. master's degree, there's an additional 20,000 H-1Bs available, so a total of 85,000. Last year, there were 800,000 submissions. Now it's a registration process for H-1Bs, and there were 800,000 registrations for the available 85,000 visas. So the demand is quite high. It turns out there was a lot of fraud last year because individuals were, I think they're, what develops often in the United States, a cottage industry around this new process. And so there was a lot of fraud, and there were multiple registrations for individuals, which generally is permitted as long as there's a valid job offer, but in a lot of those cases there were not valid job offers. So this year they changed the process to make that more difficult, and it looks like it was closer to about 300,000 submissions. So a much higher selection rate this year, which is good news. The registration period is in March for a start date on October 1st. So if you have a valid OPT EAD or STEM EAD up until October 1st, great, or beyond that, you can keep working up until your H-1B status becomes effective. Actually, if your F1 or your OPT or STEM EAD expires within the filing period of April 1st to June 30th, if you're selected in that H-1B lottery, and as long as you have a valid STEM or OPT EAD through June 30th, you can qualify for what's called the cap gap. You can keep working during the summer up until the October 1st start date of your H-1B. So spouses now of H-1B visa holders are eligible to work as long as they're through a certain stage of the green card process. They have to have at least an I-140 petition approved on their behalf, and then the spouse can qualify for a work permit. And they do allow for dual intent, meaning you can start or be in the green card process and intend to stay in the U.S. permanently and have H-1B status. Another important thing with H-1Bs is you can transfer them to new employers fairly easily. And you can start working for a new employer once an H-1B petition is filed and received on your behalf. So importantly, H-1Bs do have a prevailing wage requirement. The bad news there is the prevailing wages are really high in King County. We have very large companies here that impact the wages, and that really affects the startup community. I've definitely seen that with a lot of our startup clients. So sometimes you have to get creative and maybe find an occupation that has a lower wage. What is determinant of the prevailing wage is the work site location. And if you're working remotely, even if the company is based in Seattle, if you're working in Bend, Oregon, that's the work site. That's what determines what the prevailing wage will be. And the other important requirement, like the STEM EAD, is the employer-employee relationship. It's actually even more important. While you can be a founder of a small company and be sponsored for an H-1B, you still have to show that it's a viable employer that can pay your wage, and also that there is an actual employer-employee relationship. So it's preferable if you're not the sole owner. It's better if you're a majority owner. Anything more than a 10% ownership is considered some type of ownership, right? in the company. Question here?
So is that also like apply on the, for our PhD student would like to do a postdoc after graduation. So like being in academia, is that easier to get an H-1B instead
That's
of
correct.
lottery?
Yeah, that's a good point. If you are working for a CAP exempt organization, which would include the University of Washington, any academic institution, or an organization or entity that's affiliated, or a nonprofit organization that's affiliated with an educational institution, you are not subject to that annual lottery. So that's great news. You can get your H-1B at any time. The other option is you're not subject to the lottery if you're concurrently working for an educational institution like UW and a company. So this could be a really nice way to avoid, or if you're not selected in the lottery, to still work for your startup company. If you're working for UW, let's say, or your university for 20 hours per week and then 20 hours per week for your startup entity, you are not subject to the cap. You don't have to go through that H-1B lottery process. And this is something I just learned in the last couple of years. I feel like it's groundbreaking because of the high demand in the H-1B lottery. Another?
So that means you could have a part-time H-1B position?
Correct. Yes, and you can have concurrent H-1Bs, but you can't work for another entity unless you do have an actual H-1B petition on your behalf. Like moonlighting is not really an option unless you're a passive investor.
But if like the salary requirement was really high and you were trying to find ways around that, and somebody had like on-campus employment for 20 hours, then that would cut the prevailing wage requirement.
You still have to meet that wage requirement, like the hourly wage.
But it'd be proportional to the hours they work though.
Yes, so the prevailing wages are listed as a salary, but also as hourly. So if you are going to have an employee working part-time, you would need to say in the petition how many hours. So you would say this employee is going to work, 20 hours at blank hours or blank, dollars per hour, and that has to be at least the prevailing wage or higher. So,
but then you don't have to pay that super high.
Right, that's why I'm asking the question.
Yeah. And just so you know, and I don't know if this comes up, but bonuses, commissions, like stocks, none of that is included in the base salary for purposes of determining if it meets the prevailing wage. So only base salary is considered. H-1B workers need to be given the same benefits, basically treated the same as other employees. You also have to post the wage. There's an LCA, a labor condition application requirement, where you have to post the wage at the work site. Sometimes this can cause a challenge because a lot of US workers might see, wait a second, this H-1B worker is earning more than me. We're in the same job. And that's because of the prevailing wage, for example, because the company has to pay either the prevailing wage or the actual wage paid to other employees for the same position, whichever is higher. So sometimes the H-1B worker is earning more oftentimes. Right. We've seen that's the case.
This is all true for contractors or employees as well, right? Like contract employment's fine.
It is fine as long as there's an employer-employee relationship with the contracting, like the actual employer that sponsors someone for an H-1B. They can work on contract, but you can't work at another work site that's not listed on the H-1B petition if it's in a different metropolitan statistical area. So what you just want to be careful about is like it needs to be in, let's say, King County. It's actually King, Snohomish, Pierce County now.
Right.
It's expanded a bit, which is nice, but you can't be like working in Oregon or something like that if it's not listed on the LCA.
Right.
Another question?
Yes, another question. So is that J1 visa qualified to work? Like the people holding J1?
Oh, J1, and I didn't talk about J1s because I feel like that's another can of worms, but J1 is another really good option for work, for research scholars or interns like at startups. A lot of our biotech companies have J1 interns. You have to have a program sponsor, so it can be a university like University of Washington, or a sponsor agency. So there's a lot of sponsor agencies that work with companies. They have to like make sure it's a viable entity and meet certain requirements.
Right, right. And with the J, you know, sometimes if you're from a country that requires you to go back to your home country for 2 years, it could be difficult to change status after.
Then you have to get a waiver. There's a 2-year foreign residence requirement if your field is listed on the skills list for your country of nationality, for example. And that process is possible. You can get a no objection letter from your home country, and that's probably the most commonly used J1 waiver. But you can't get an H1B or an O1 or a different type of visa unless you get that waiver first. So that's something to really think about early if you're on a J1 that's subject to that 2-year foreign residence requirement. Another question?
Yes. How is the process different for a Singaporean citizen who's starting up a company in the U.S.?
Do you want to talk about
Sure,
H1B1?
yeah. So H1B1, so there's an extra 1 at the end. It's very similar to H1B with the requirements, but individuals from Singapore and also from Chile, they are exempt from the lottery. They have a separate kind of cap on H1B1s, but we never reach it. So they don't have to have a lottery. They can just get an H1B1 visa. The requirements and eligibility requirements are still going to be the same. And so if you're a founder, you need to make sure that you have an employer-employee relationship with the company. And I will also like to add that for H1Bs and H1B1s and E3s, which are specific to Australians, you still have to be in a specialty occupation, right? So you can't just be a founder and I'm going to just be managing the business. I'm a business owner. That's not a specialty occupation. So you need to think about what your role is going to be for the company. Make sure it is a specialty occupation, and then make sure that the degree that you have qualifies you for that H1B specialty occupation position.
Often it can work if you're the CSO as opposed to just the CEO founder, for example, if you're on an H1B. The O1 or different visas might give you more leeway in that area to be like the CEO founder. The other thing is the H1B1, you can apply directly at the consulate, so you avoid these messy filing fees, all these high filing fees for filing with the Immigration Service. And there's a little bit less scrutiny generally.
Right, generally. Right? The consular officers, they spend, I'm going to say, 10 minutes or so looking at a packet. And so it's going to be a little bit easier to get your petition approved at a U.S. embassy or consulate abroad. And you can do that for H1B1 petitions as well as E3 petitions. And again, E3 is for Australian citizens, but it's basically an H1B.
You can also stay on an H1B1 for an unlimited time period. Same with the E3. The E3 is for Australian citizens, much like an H1B or H1B1. There's no lottery, no cap. You can get the E3 is 3 years, 2 years at a time. The H1B1 is basically 1 year entry at a time. So that's a big challenge with the H1B1 is it requires usually a lot of travel back to your home country. You can file an extension with the Immigration Service otherwise. But also with the H1B1, it's much more limited in terms of green card, like your ability to stay in the US permanently. So it has a very strict, like a TN visa, you cannot intend to stay in the US on a permanent basis. So that can be tricky if you keep extending that H1B1 for several years. So just a quick overview. We don't have to really do this because we don't have a whole lot of time. The filing fees are really high. They just increased on April 1st. The good news is if you have fewer than 25 employees, they're a little bit lower. It's, I think, for, the H1B petition, which is Form I-129, it's $460. There's also a fraud prevention fee, $500, $700 fee, training fee or sponsorship fee, and now there's a new asylum program fee. We don't really know what that's about. It's $300 or $600 if you have more than 25 employees. The nonprofits or like academic, I think universities don't have to pay that asylum program fee. Premium processing is also really high. It's $2,805 to get your petition processed within 15 business days. It used to be calendar days, and now it's business days. So more money for less quality customer service. Right. That's kind of the name of the game.
Right.
You said an alternative application process for a petition is through the U.S. consulate in the country that the
Yes, but
beneficiaries from.
only for the nationals of Chile and Singapore who
right.
apply for the
Australia.
H-1B1, or Australia if they apply
Got
for
it.
an E3.
That makes.
Unfortunately, other folks aren't eligible for the direct filing, which is, avoids all of this.
Right. And this has to be paid by the employer, so the employee cannot pay for really any of it, except for maybe premium processing because the employee has some travel for their own vacation and they just like to get, the petition approved.
We have another question in the back.
Yes. Can an H-4 start a company in the U.S.?
If you have a valid EAD, yes. So if you have a spouse of an H-1B visa holder, you have a work permit as an H-4 non-immigrant or visa holder, you can start a company. You basically have unrestricted work authorization. You can work anywhere you want and start a company, kind of do what you want. There's a lot of flexibility. The good news also is now when you file an extension of your work authorization, you have automatic work authorization while the extension is pending. That used to be a big issue for spouses of H-1B visa holders.
Yeah, except for one caveat with the H-4, so the dependents of H-1B individuals, they have to make sure they have a valid I-94. So unfortunately, if your EAD and your status are expiring at the same time, you can't benefit from the automatic extension rule.
And if the H-1B visa holder, the employee loses their job and doesn't find another H-1B employer within 60 days, I guess we didn't even talk about this stuff, but maybe I passed over it. But you have a 60-day grace period. If you're on an H-1B and your employment is terminated, and we've seen this a lot since the pandemic in the last few years, there's been a lot of layoffs for H-1B workers, and you do have 60 days to find a new job and have an H-1B petition filed on your behalf. That 60 days is tough. It goes quickly. The good news is the Immigration Service said it's 60 days from your last day of pay, not your last day of work. So sometimes employers might allow you to be compensated for an additional month, so that kind of buys you more time to find a new job. But also the spouse, if they're on an H4, it affects their status. So if you don't find another job within that 60 days, you could affect someone on the H4 EAD. So anything else on H-1Bs? Do you guys have any other questions? I think H-1Bs are still a really good option for startup founders, particularly if you think your business will grow. If it's really going to be a 2 or 3 person business, then you might want to look into alternative visa options, because this might just get more difficult if we have a new administration. This was definitely a priority of prior administrations, to really focus on that employer-employee relationship. The current administration is very favorable to startups, so we are seeing a higher approval rate even for companies with fewer than 5 employees.
Right, yeah, I've seen that too.
And if you can show funding and all of that, like the viability of the business, you have a much higher chance of approval. So were you?
Yeah.
TNs? Yeah.
Yep, so now we're going to talk about TNs, mainly in the context of an employee of a startup. It's difficult to be a founder on a TN, but the TN visa is for citizens of Mexico and also Canada. It's based on a treaty that we have with the 2 countries. It's great, but also it's limited. It's limited in that we have a list of occupations in the treaty where an individual can come in and work on a TN visa. And so if your employee of your startup is on the occupation list, that's great. But the more common ones we have listed up here are computer systems analyst, engineer, and that could include mechanical engineer, computer engineer, all kinds of engineers, scientific technicians, and technologists. It's a little bit more difficult, but it's positions where they are supporting somebody with a bachelor's degree in a scientific field. There's also economist and management consultant. So you'll have to think about the position that you have open for your startup, and then also the individual that you want to hire. They must be a citizen of of Mexico or a citizen of Canada, they must have the required degree for that occupation. Generally, the degree has to be related. There's some flexibilities, more than I would say an H-1B in some sense, but it should be related. So no self-employment, so you can't be a founder and work on a TN. I suppose if you have a very small percent ownership of the business, you can argue that you still have an employee-employer relationship with the company that you founded. But again, your position as founder has to be in the list of occupations on the treaty. For Canadian citizens, they can apply for the TN visa directly at the border, so at the land border or at the airport. But for Mexican citizens, they have to go to the U.S. consulate or embassy in Mexico and get a visa to come into the U.S. In TN status, unless they're already in the United States, in which they can file with USCIS. They can have 3 years of status at a time, and it could be renewed indefinitely, but you can't have the intent to remain permanently.
Our primary recommendation with TNs is avoid that land border crossing between Seattle and Vancouver. It is tricky. It can be really tough to get approved. If you go through Vancouver, they're very business friendly and generally immigrant friendly. We have a good relationship with the supervisor there. They actually respond to our requests. It's a big difference. I think the land border crossing is just kind of more enforcement minded and less business minded. So we usually recommend, especially the Vancouver airport. Not all airports. Toronto is not the easiest, actually. Any questions about TNs? Anything? Okay, E2s.
E2s, all right. So the E2 is a visa for an individual who may want to invest in a company or have a company in the United States, or it could be for an employee of a company who was, there was an investor who invested in that business. The investment must be substantial and at risk, and substantial but also reasonable for that type of business. It's generally about, I would say $100,000 is probably a common amount, but it has to be realistic for that type of business. So, if you're going to have a business with a bunch of expensive medical equipment, maybe $100,000 isn't going to cut it. But you just have to think about what's kind of realistic for your company and what's going to start that business and start running it. The caveat to this visa, it sounds great, but you have to be a citizen of a country in which U.S. has a treaty of commerce with. So it's not available, unfortunately, to everyone. But if you are from a country that has a treaty with the United States and allows for an E2 visa, this is a great option if you're a founder, if you want to start a business. Unlike the H-1B or even OPT, you don't have to have a degree that's related to whatever business you want to start. So that's great. And then if you're an employer of an E2 investment business, you just have to have the same citizenship of your investor or of the company if the company is investing in another company. So just like kind of a summary of what I just said. So if you're starting your own business, you have to be from a treaty country that's listed there. The investor must invest money into your business, and it has to be at risk. You can't just put your money in a bank account because there's nothing happening with it. You have to buy equipment or maybe get some sort of office space, hire folks. You have to complete kind of a packet or a business plan to be able to show Immigration Services or U.S. Consulate Abroad that you have a viable business and that it has the potential to make money to support other employees, not just yourself and your family. The application can be made through USCIS or at a U.S. Consulate Abroad, and you're admitted for up to 2 years at a time.
Great. So we have very little time, so I'm going to breeze through the next couple slides. I'm not thinking you see a lot of L1s, but the L1 visa is usually for intra-company transferees. So big companies like Amazon and Microsoft use it to transfer people between subsidiaries, parent companies. You can use it to open a new office, and you can get it approved for up to a year to open a new office, but you do have to have an existing entity outside of the US to do that. So if you're really starting a new enterprise without any existing entity outside of the US, probably the E2 or some other type of visa is going to be a better option. And you should be working in this, or have an employee, you could sponsor an employee as a manager, executive, or specialized knowledge employee on the L1. But the O1 is one that we do use a lot for folks in this, like incubators, startups, small to mid-sized companies, because it's a great option, and it sounds more difficult than it is. You know, you have to show you have extraordinary ability in some field, arts, science, business. So if you have the criteria of winning a Nobel Prize, great. You got it. You can get the O1. But the good news is you don't have to have that. You just have to meet 3 of other criteria to qualify for the O1 visa. So it's a really good option. It's a great backup option if you don't get selected in the H-1B lottery, if you meet 3 of these criteria. You have to have prizes or awards. That's more than just fellowships, like an academic fellowship. It should be something that's national or international, you know, in the field that's more significant. Membership in associations that require outstanding achievement for their members. So there should be some criteria to join the association other than just paying a membership fee. Published articles in major media. That's generally published articles about you. So let's say that you're featured in GeekWire or some cool, you know, PSBJ or whatever. It doesn't have to be, you know, CNN doing a piece about you or the New York Times. Major media is loosely termed there, I think. So if there's articles about you or even citations to your work, they will consider that, especially if your work and your name is actually discussed in another article in the citation. That's really helpful. We usually use like the Google Scholar to figure out, you know, how many citations and what kind of, you know, how high someone's article is recognized. But even if you have just a few published articles, if they're widely cited, you can meet that requirement. Another question?
Thank you. So the publication is not necessary to be the first author of the paper, right?
Correct.
For the citation part.
That's correct. So the question is, do you have to be the first author? And no, you don't. It's helpful if you're one of the first 3 authors. You know, if you're up there in the list, or at least you're the first author of one article. You don't have to be, but you can definitely rely on articles that you're not the first author. Another question?
Do you ever have clients who are like thinking maybe a year or 2 down the road about submitting a petition and kind of building a case?
Yes.
Starting now instead of like, how can we do this in 3 weeks?
Yep.
Like, what do you
absolutely. We recommend starting in undergrad. I mean, starting as soon as you can, you know, but certainly in graduate school, postdoc, you know, whatever type of research you're doing, focus on these criteria. Take a look at them and see where you can start to build your resume.
So like, it would make, like if you had a set of candidates, say you had 2 or 3 that you were thinking about writing a petition for, like between a year or 2 years out, like we could submit like a set of candidates to you and you guys could make recommendations as to like, these are going to fall way short, or these are good candidates to try for, or these are already ready.
Absolutely.
And then like, don't go forward with actually the petition, but rather just like see where the case stands.
Correct, yeah. And the O1 is different than EB1A, which you've probably heard about, or even a national interest waiver, right? The criteria are different. You have to meet 3 as opposed to 4 of the criteria. So just remember, the O1 visa is a temporary visa. The standard's a little bit lower. So you might qualify for the O1, but you're still not quite ready to have an EB1 or EB2 national interest waiver petition filed on your behalf.
Yeah, I agree.
But yeah, that's great. I think thinking about this early while someone's on OPT or STEM EAD, because of the limitations of the H-1B lottery, the O1 is a nice option. The other important thing with the O1 is it allows for self-sponsorship. You don't have to have an employer sponsor. I mean, that's like really unique to the O1. Most of the other categories require an employer file a petition on your behalf. It's usually stronger if you do have a petition filed by an employer, even if it's your own company on your behalf, but you can have it filed by an agent on your behalf. So other ones are high salary, judge the work of others. That's like being asked to review articles. So offer your services. You know, I often tell folks, like, get out there and, you know, offer to review articles or be on panels, get out there and speak at conferences. It all helps to build your resume for the O1. Yes,
So I have a question about the membership in associations. Is that, like, actually for example, like, I'm a member of Biomedical Engineering Society. Like, is that, what kind of membership, specific membership is required for this?
So does it require more than just being in that, working in that field or having a major that's in that field of study? Do you have to meet a certain standard, like have a certain amount of articles published or have a certain even GPA, or, you know, to be a member?
Or maybe you have to be
association.
invited.
Actually, just
you know,
like,
something.
many of them just need to, like, you pay for the fee and then you can be part of it.
Yeah, so those might not qualify as much. We usually like to show there's some type of membership criteria that's more than just paying like an annual fee.
Like a fellow of the association?
Yeah,
Okay.
yeah. Or if you're in a leadership position of the association, I think that would definitely be a factor. So was I still doing?
Yeah,
Let's see.
yeah.
O1s, you can get the O1 for 3 years initially and then extend. And you can do it unlimited. You know, again, unlike the H-1B that has the 6-year maximum, the O1 you can keep extending. Often people go for the green card, you know, at some point. Maybe they'll extend it a couple times and then apply for a green card under one of those categories I mentioned. And this talks kind of about how you can use it, the agent option. We usually only do agents for arts. You know, we do O1s for individuals in the arts. I used to work with PMB and we did them for dancers or, you know, artists. But it's a great option for scientists, even folks in business. You know, you don't have to have research publications to meet the criteria to qualify for an O1.
Yeah, that's true. I got one for a club promoter once.
Athletes, obviously, is another area. So quick, we wanted to talk about the international entrepreneur role. I have never filed one of these.
No, me neither.
So, you know, this is limited knowledge based on our research and talking to other practitioners in the field. But there is this new rule called the International Entrepreneur Rule that allows you to come in for up to 5 years to grow and start a business. You get it actually for 60 months at a time, 2.5 years.
Yep, sure.
And you know, you have to have a substantial ownership interest. The startup must have been created in the last 5 years. And it must have substantial potential for rapid growth and job creation. So we usually have to show you've got funding, you've secured some funding for the startup, or you have a really good business plan. You need to have a central and active role in the startup. And you want to show you're going to provide substantial public benefit. Like there's some national interests you're serving. Let's say it's a biotech that you're going to, you know, cure cancer, or, you know, it's going to have future, you know, impact on the economy. This is a really, you know, profitable, this is a great idea. And you have some letters, let's say, from experts saying, yeah, we think this is going to make a real impact on the US economy. It's a parole, so it's not really a permanent, certainly not, doesn't get you a green card. And it's even maybe a little less valuable than a temporary visa.
Yeah, I would say so. You can't change status when you're on a parole, so yeah, it's kind of limiting in that aspect. But you can have it for up to 5 years. You can extend once.
So it might be an option, again, if you can't get the H-1B, you don't qualify for the O1. I mean, it's something to think about. You might qualify.
Right,
Are
we're
you
gonna- yeah,
talking
I'm-
about?
yeah, but I'm
So
gonna
quickly,
speed
we want to
through.
talk about the green card options for startups and founders and employees of, you know, smaller companies, because there's a lot of different options to get permanent residency or a green card in the U.S.
And in the US, there's 5 preference levels for green cards. And so we're going to just talk about certain ones that are applicable here. The EB1A is for individuals of extraordinary ability. It's very much like the O1 that Amy just talked about, but it's a higher standard, so I'd call it maybe a grown-up O. We listed the criteria that's more relevant to the topic of startups and entrepreneurs, but basically if you are judging the work of others, you have awards and prizes, you are a member of associations where you're being invited, things like that. And so once a petition like this is filed, most of the green card processes in the US are two-step processes, an immigration petition, and then the actual green card application. Depending on your country of birth, it might be a long wait until you're actually eligible to file that green card application, even after you get the immigrant petition, such as the EB-1A petition, approved. So it might be something you want to think about kind of early on, and you want to make sure that you have underlying status, because the green card category doesn't allow you to stay in the US and work. It's kind of a separate parallel process. So I'm just going to speed through.
So EB-1, yes, and this is another form of the EB-1. So this is outstanding professors and researchers. If you're in a research position at a private entity that employs at least 3 individuals in research, you can qualify for the EB-1B. It's a little lower standard than EB-1A, very similar criteria. But it's a great option. If you're from India or China and subject to the backlog, as you probably heard, it's really tough to get a green card from those countries. EB-1 is a nice option if you either qualify for the extraordinary ability or as an outstanding professor or researcher. UW sponsors a lot of it. I think you have to be tenure track, like it's not available for a postdoc, but it's available for like tenure track positions. They'll sponsor for the EB-1B category. And then there's national interest waiver. This is probably the most commonly used visa category for individuals, especially in startups, in the biotech field especially. But if you can show that the work you're doing is in the national interest, you can qualify for a green card under it's EB2, so it's a different preference category than the EB1A and B. But you qualify for a green card under that EB2 category. And you don't have to go through this PERM, a labor certification, which you might have heard about, so you don't have to show there aren't available and qualified US workers who could do your job. There's 2 criteria. You have to be a member of a profession, holding an advanced degree, or demonstrating exceptional ability in the field. And then you have to show it's in the national interest to waive the labor certification requirement. So generally, your work should have what's called substantial intrinsic merit. Who knows what that means? I mean, there's some case law interpreting it. We usually just like to show the work you're doing is really going to help some aspect of the country. If it's the US economy, that still counts. Again, you don't have to be curing cancer to be doing work that's in the national interest. And these are some of the criteria similar for exceptional ability. If you don't have that advanced degree, you can meet 3 of those criteria. So the substantial intrinsic merit, national importance, you have to show you all are also well positioned to advance that endeavor, that you're going to be working in that field, and what are you going to do to make a difference. Reference letters from experts in the field, usually we submit at least 4 to 6, if not more, reference letters. That can be really instrumental in showing that. But just know that EB2 is not, it doesn't, you still are subject to that backlog, especially if you're from India or China. It can be really lengthy, 10 to 15 years right now for nationals of India to qualify for a green card under that EB2 category. And then quickly we talked about PERM, but right. I think we might have to end, right? Okay.
Just really quick, PERM is generally for employees of a startup. You can't be a founder and do a PERM. It's for EB2 and EB3 preference categories. It's going to be a 3-step process instead of a 2-step process. And it's because there's the PERM step in addition to the immigrant visa and then the green card application. And the PERM is basically your employer saying that there are no qualified US workers who are available to perform this position. For jobs that require at least a master's degree or a bachelor's degree and 5 years of experience, you can file the immigrant petition under the EB2 category. But if the position only requires a bachelor's degree or maybe just 2 years of experience, then the immigrant petition can be filed under the EB3 category.
It's much longer. So that 3-step process, especially for PERM right now, it's taking about 2 years from start to finish to get a PERM approved. because Department of Labor has made all kinds of changes and new forms, and the other challenge we're seeing is that with layoffs, if you have a layoff, you can't file for a position that's similar to the position you want to sponsor someone for, you can't file a perm on their behalf.
Right.
So a lot of companies have stopped doing perms temporarily because of the layoffs, or they're seeing a lot more applicants for positions. Also, nowadays in Washington State, you have to list the wage on all ads you post for a position. So a lot of companies, might not want to post ads, especially if the prevailing wage is quite a bit higher than the wage they're generally paying to their employees. So there's all kinds of factors to think about in perm, but it's an option to get a green card. So it was great speaking with you. I think we're done today. Let us know if you have questions. We can also address questions afterward. We'll be here for a bit. If you have any questions, come on up and chat with us. But thank you so much for inviting us.
Thank you for joining us today, and from everyone at CoMotion Labs, a big thank you to Amy and Cody for sharing their expertise with us. Next Friday at noon, Ben Strahan and Steve Merriman, partners at Perkins Coie, will present compliance tips for federal reporting requirements. Sign up today, and we'll see you next week.